Hello. Today I'm going to read an article that was published in the ABA Law Magazine. It's written by Erwin Chemerinsky, who is the Dean of the California Berkeley School of Law. Now, I would agree with almost everything he says, and I'll go into that as I read it. The name of the case basically is Taylor versus Riojas, and it deals with qualified immunity and how the Supreme Court finally made a decision where it said that lower court judges don't have to use qualified immunity when the acts are egregious. Okay. The Supreme Court made a decision without oral argument. The issue is about qualified immunity. That means it determined when a protected group is immune from their actions. In Taylor versus Riojas, the court decided that prison guards can lose their immunity. The case is significant because the High Court rejected a claim of qualified immunity and made clear that no case on point is required in order to hold the government or official liable. Obviously, it will be an aberration because of extreme facts, but a victory in the Supreme Court for a civil rights plaintiff in a qualified immunity case is surprising. There have only been about 3 cases in the last 30 years where the Supreme Court has questioned qualified immunity. Taylor versus Ryogas has shocking and has very disturbing facts. Taylor is a prisoner in Texas. He entered a psychiatric prison unit to receive mental health treatment following a suicide attempt. For a period of 6 days, he was confined in a pair of unsanitary cells. The court explained that the first cell was covered nearly floor to ceiling in massive amounts of excrement. The floor, the ceiling, the window, the walls, and inside the water faucet. For 4 days, Taylor did not eat or drink for fear of contamination. He was then moved to a very cold cell with only a clogged drain in the floor to dispose of bodily waste. The court said Taylor held his bladder for over 24 hours, but he eventually relieved himself, causing the drain to overflow and raw sewage to spill across the floor. Evidently, Dean Chemerinsky doesn't want to say that one of the guards said, "I hope he fucking freezes to death," because that wouldn't be right in a magazine or a law journal. But effectively, that's what happened, and that's what he said. In any case, in the second cell, he finally had to go, and since the drains were not working, he was sleeping in his own excrement. The cell lacked a bunk, and because Taylor was confined without clothing, he slept naked in raw sewage. Taylor sued the corrections officers, alleging they violated his 8th Amendment by inflicting cruel and unusual punishment. The district court ruled in favor of the defendants based on qualified immunity, holding that they could not be held liable because they did not violate clearly established law that every reasonable officer should know. The U.S. Fifth Circuit Court of Appeals affirmed the dismissal of Taylor's case. The Court of Appeals ruled that Taylor's constitutional rights were violated. Being placed in these cells was cruel and unusual punishment. But it also concluded that the officers were protected by qualified immunity. It said the officers could not be held liable because the law wasn't clearly established that prisoners could be housed in cells teeming with human waste for only 6 days. The High Court's decision. In a 7-1 decision, the court reversed the Fifth Circuit in a per curiam opinion. That means it was by the other justices on the court. The court held that the officers were not protected by qualified immunity because no reasonable corrections officer could have concluded that under the extreme circumstances of this case, it was constitutionally permissible to house Taylor in such deplorable, unsanitary conditions for this extended time. The court said, confronted with particularly egregious facts of this case, any reasonable officer should have realized that Taylor's condition of confinement offended the Constitution, the Eighth Amendment. Why does this matter? Any government official sued for money damages for allegedly violating the Constitution has an immunity defense. Some are protected by absolute immunity, judges for their judicial acts, legislators for their legislative acts, prosecutors for the prosecutorial acts, law enforcement personnel for the testimony, and the president for acts taken in carrying out the duties of his office. Chemerinsky doesn't say that judges lose immunity in certain cases. I think one of them is called Forrester versus White, where Justice O'Connor wrote the decision. And she found that judges lose their immunity in administrative, legislative acts. All other government officers have qualified immunity when they are sued for money damages. That's not entirely true, but we'll leave it go because he's a dean and I'm not. Over recent years, the Supreme Court has expanded the protection of officers under a theory called qualified immunity and repeatedly stressed the need for plaintiffs to show a case on point in order to establish liability. The court has said that a plaintiff can overcome qualified immunity only by proving that the defendant officers violated clearly established law that every reasonable officer should know, and that it is a right established beyond dispute. That's a lot of garbage because you can tell when something isn't right. It doesn't have to have a case behind it. The court stated, existing law must have placed the constitutionality of the office conduct beyond debate. The demanding standard protects all but the plainly incompetent are those who knowingly violate the law. To be clearly established, a legal principle must have sufficiently clear foundation in then existing precedents. That means there have to be cases that correspond, and frequently they aren't. The rule must be settled law, which means it is dictated by controlling authority or a robust consensus of cases or persuasive authority. It is not enough that the rule is suggested by then existing precedents. The precedents must be clear enough that every reasonable official should interpret it to establish the particular rule the plaintiff seeks to apply. In case after case, the Supreme Court found officers were protected by qualified immunity under this standard. From 1982 to 2020, the court dealt with qualified immunity in about 30 cases. The plaintiffs prevailed in only 2. Hope versus Pelzer, which is a 2002 case, and Grote versus Ramirez, a 2004 case. Thus, the court's ruling in Taylor versus Riojas for the plaintiff and denying qualified immunity is notable in itself. It happens so rarely. But the court's reasoning also is potentially quite significant. The court, in its per curiam opinion, relies on two earlier decisions, United States versus Lanier and Hope versus Pelzer. These are a rare case where the court said that there does not have to be a prior decision on point to overcome qualified immunity. United States versus Lanier in 1997 was not a civil suit under 1983, but rather was a criminal prosecution under 18 U.S.C. 242. Both 1983 and 242 were enacted as part of the Civil Rights Act of 1871. It's a long time ago. The former creates civil liability and the latter criminal liability for those acting under color of state law who deprive a person of rights protected by the Constitution. Lanier involved a state court judge who had sexually assaulted and harassed women in his chambers. The U.S. Court of Appeals for the Sixth Circuit ruled in favor of Lanier, emphasizing the absence of prior decisions explicitly deeming such conduct to be a violation of constitutional rights. The Supreme Court reversed and stressed that a reasonable person surely would know that such behavior is a violation of a woman's constitutional rights. Since when does rape become qualified immunity? I don't know. Realize that you had at least 3 appellate judges saying that this judge shouldn't be prosecuted. In Hope versus Pelzer, a prisoner was tied to a hitching post as punishment and left in the hot sun for many hours. The 11th Circuit found this to be cruel and unusual punishment, but said that the prison guards were protected by qualified immunity because there was not a prior decision that the use of the hitching post was unconstitutional. Can you imagine that? Tying someone to a hitching post in the hot sun, and that's not unconstitutional. So they were evidently, Supreme Court reversed and ruled that the defendants were not entitled to qualified immunity. The court, in an opinion by John Paul Stevens, held that the key inquiry is whether the officer had fair notice that the conduct was a violation of rights. Stevens explained that the central question in determining whether prison officials could be held liable to Hope was whether the state of the law in 1995 gave them fair warning that their alleged treatment of Hope was unconstitutional. The court explained, although earlier cases involving fundamentally similar facts can provide especially strong support for a conclusion that the law is clearly established, they are not necessary to such a finding. Rather, a plaintiff can overcome qualified immunity by showing that the reasonable officer, under the circumstances, should have known that the conduct was wrongful. You shouldn't tie someone in the hot sun for 7 hours. The court then reviewed the law as it existed in 1995 and said that the officers had fair warning that their conduct was unconstitutional. But in the almost 2 decades since Hope versus Pelzer, the court repeatedly blocked away from this approach and continually stressed the absence of cases on point as a basis for dismissing a case based on qualified immunity. The court did not overrule or attempt to distinguish Hope versus Pelzer. The court just ignored Hope versus Pelzer. Taylor versus Riogas is especially important because it reaffirms Hope versus Pelzer, and it does not have to be a case on point for a plaintiff to prevail and overcome qualified immunity. There was another case that Ruth Bader Ginsburg dissented on, and I think there too it was a case where someone sued a district attorney for failing to give information to the defendant, and that would be a violation of Brady. Okay. In conclusion, in recent years, the court's qualified immunity decisions have come upon sharp criticism by both liberal and conservative judges and commentators. Proposals have been introduced into Congress to modify the law in this area. Perhaps Taylor and Riojas is a response to the criticism and will lead to a court that will be more willing to rule for plaintiffs when qualified immunity is the issue. Or maybe the case just is a reflection of truly horrific facts and will be an outlier in the court's future decisions in this area. No matter what, it is an important ruling that has the potential to matter greatly in lower court litigation in establishing that Hope versus Pelzer remains good law and it does not have to be a prior precedent on point to overcome qualified immunity. Justice Thomas dissented without any opinion. Justice Alito concurred with the opinion, but believed that the court did not have to hear this case directly, but could have waited until the case was heard in the lower courts. Alito's concurring opinion was longer than the per curiam opinion, and it's really not easy to understand. Okay, hopefully sometime in the future we'll get another case where prosecutors' actions are questioned, because there are a hell of a lot of them that don't function well and they're protected, and there are times that should not be. Okay, glad to at least read this to you. I suggest you look up the cases online because they're totally outrageous.